Absa wants to challenge in court what it describes as the public protector's irrational and unreasonable report. The bank believes it doesn't have to pay back over R1 billion in interest from an apartheid-era bailout given to its predecessor, Bancorp. That's because it says it's met its obligations to the Reserve Bank and others by October 2015. Now, it wants the report to be overturned because its findings, it says, are based on misrepresentations and factual inaccuracies. Well, to help us understand that point, we joined in the studio by a spokesperson for Absa, Songezo Zibi. Songezo, good morning and thank you very much for coming in.
Good morning, Dan.
Let's start there. On what basis is Absa saying the public protector's report has come to irrational and unreasonable conclusions?
Thanks very much. We're saying this because in the provisional report, the public protector had relied, it seemed to us, or our reading of it, on an alleged testimony by the former governor of the Reserve Bank, Crystals, and also a document that he purportedly produced, which showed evidence that Absa had this obligation to the South African Reserve Bank. Dr. Crystals, immediately after the report came out, the provisional report was leaked, came out and said he never said such a thing and that such a document did not exist. In fact, we were of exactly the same view because we were not aware of this document. Now that that claim has been refuted, the public protector is relying on the Davis report to say that Absa has got an obligation to pay just over R1 billion. Unfortunately, the public protector then omits the rest of the page in the Davis report, which says that Absa paid fair value for Bancorp and that the price that Absa paid for Bancorp in 1992 included the assistance that was still to come from the Reserve Bank, and that if there was to be any claim against anyone, it would be against the shareholders of Bancorp who received the purchase price from Absa instead of part of that purchase price going to the Reserve.
And who were those shareholders?
So the shareholders were it was before demutualization, I think you'll remember this. So the policy holders of an insurance company as well as pension fund members would become shareholders in an entity in which their premiums had been invested. They were the 88% shareholders of Bancorp. And the 1.23 billion rand that was purchased, that Bancorp was purchased with, most of it went to the policyholders of Sanlam. And Judge Dennis Davis found in 2002 that part of that money should not have gone to them, it should have gone to the South African Reserve Bank.
Okay, now, in your statement this morning, you also say you believed you've paid a fair value and that this issue was resolved by October 1995. Am I to understand in that Absa is saying we have paid that 1.1 billion rand to Reserve Bank by October 1995, rather?
In fact, Absa paid upfront before that. Let me explain what the obligation was because it's very important. What had happened then is that the borrowers of Bancorp had not been able to pay their debts between 1985 and up to that point. And because if that situation had prevailed, then the depositors would not have been able to get their money from Bancorp on demand as a bank is supposed to do that. So the Reserve Bank stepped in. So what happened and the Reserve Bank insisted upon was that each and every one of the 91,000 clients and customers, so these were companies and individuals with different kind of debts with the bank, there had to be an account of how much their debt was being written off and why. And all of this was independently audited and this information submitted to the Reserve Bank. By October 1995, all the people on that list had been accounted for with specific amounts next to their name. And that was an obligation then that Absa had to the Reserve Bank to account for each and every cent. By the way, we had offered the previous public protector an opportunity to go through these records and all the contracts, which never happened, unfortunately, until this year.
Did the current public protector look at those records?
After initially refusing, she eventually did on the 16th of February this year. And we made our final submission on the 27th of February this year.
There is also the matter of the Heath investigation, and yes, whose report, as I understand, was never made public.
Yes.
At the time. And it's reported to have said that this can be regarded as a donation. We've never seen the report myself, but there were reports about it to say Judge Heath has said that it was a donation that was partly faulty, should not have been done. If you hear that, don't you think Absa today has an obligation to say, let's give back the donation?
Good question, then. Thanks very much for it, because there are two things which are common cause, by the way. The first is that the manner in which the assistance package was put together and done was unlawful. This is common cause. The SA Reserve Bank Act at the time, according to the interpretation of both Judge Heath and Judge Dennis Davis, did not give the SA Reserve Bank to execute this in that way. Common cause, done. Secondly, what is also common cause is that in these bailouts, the shareholders of the bank that is in trouble are not supposed to benefit. Hence, Judge Dennis Davis says the money that Absa paid should not have gone to the shareholders of Bancorp, should have gone to the Reserve Bank. That's the illegal gift. The key question is, who received the gift? Is it Absa or is it the shareholders of Bancorp? The answer is, in our view and in the view of the Davis panel, are the shareholders of Bancorp, but Judge Heath felt that it was Absa. And that's part of the reason why we believe this must go to the High Court, ventilated in public, every little detail scrutinized in public so that the public can know what the truth is.
Currently on social media and generally in public, Absa is viewed as the bad boy.
Yes.
In terms of an apartheid, having benefited from an apartheid era type of an unlawfully given gift, as you've just described, by the Reserve Bank, that they were not supposed to do. In that circumstance, how do you think Absa can correct that? I mean, you're going to take this on review, but in the opinion of the public, Absa is the bad boy. What can you do ahead of that review to ensure that Absa is not seen, continue to be seen as the bad boy? I mean, political parties are commenting on it, and general public are saying, Absa was set up by using illegal monies from the apartheid regime.
Well, what we have to do is to do this, speak to you, for instance, and your colleagues in the media, to put out information in the public domain. So we're putting out a lot of information on our website from today, which explains what this was about, how much was given to whom. We're putting out the Davis panel report out. Unfortunately, the Heath report is not available to the public. We can't, otherwise we would. What I would also encourage the public to do, then, is to read the SAIEX report themselves. It is not worth the piece of paper it is written on. In fact, I encourage viewers of eNCA to read the SAIEX report.
Now, are you saying the public protector has reached wrong conclusions?
Absolutely. The court must set the record straight, and that's why we're going to court.
So Absa is not going to make good on the 1.1 billion rand?
And it is not about the money, because already between last year and 2018, we'll have contributed over 1.4 billion rand to education. It's not about the money. Even if this debt was 1 million rand, on the principle of what is contained in the facts and the records, we are going to go to the High Court to challenge this, and we would have challenged it anyway because it is untrue.
And what about allegations that people are using those terms now and saying, yeah, this is a capitalist corruption, they benefit from that, and Absa needs to fix this to make sure that going forward we know that they are clean? How do you respond to those kind of comments?
Then I can understand in a country with a history such as ours, especially where after 1994, a lot of us feel that just about everyone except Eugene de Kock in the former regime got off scot-free. And the cry for justice is understandable. The cry for justice in the instance of looting, of which I am certain there were many, many instances, is fully justified. But we cannot ban someone every time somebody points and calls them a witch, just because we've got this yearning for justice. Facts are important. To the extent that this country needs to pursue debts and other crimes, it must be done on the basis of the correct facts. And in this case, we do not believe the information available bears that out in the case of Absa.
And very briefly before you go, and you've got the list of the names of those shareholders.
Each and everyone.
Who benefited. And they're the ones that therefore they should be talking to repayment.
Each and everyone. And Dennis Davis said it would be impossible because if you've got a policy holder, if you've got a policy and you die, who pays the claim?
Okay, thank you very much. That's Absa spokesperson Songezo Zibi. More news on the other side of the break.